for FINRA broker-dealers, funding platforms, and marketplaces alike. Once again, I'm so glad to have our panelists, Mitch and Marty, back. We are going to get started soon, but first, before we get started, we just want to say a quick thank you to our sponsors who wouldn't this be possible today to bring you this series with Nuvei, our Canadian fintech company providing payment solutions for the private capital markets. It's exciting to be able to have companies who are supporting these initiatives of education. Of course, the KoreConX all-in-one platform providing the private capital market. So today is kind of going to be, if you've been following our series, I think today, I believe it's going to be kind of very interesting putting them all together. Today, we're only going to focus on KYC, and this all got started because of what Mitch said. So I'm going to pick on Mitch, but a little bit. But today, so what I liked about the last conversation, which I've taken notes, and I said, you know what, that's a great way to approach how we're going to discuss how KYC is different for Reg CF, Reg A, and Reg D. But I want to start it from the beginning, Mitch. I want to get that conversation because that's what it's going to be about today, the KYC, the differences, and then we're going to dig into each differences specifically. But let's start, how should a firm or anybody approach this? Because you brought up some interesting points last time. It was just part of it, but I want to dig deep into that, why it's so important for that to be there.
Yeah, so I think I know what you're talking about, and I'm just going to go where, the point that I think that you're referencing that I made, at least I think it was on last week's call. But first and foremost, if you're a firm that's going to participate in Reg CF, Reg A, Reg D deals, you have to first start by identifying the key differences in the requirements for each type of offering. And the point I made last week is the best thing that we do for our clients at CRC is we will help them initially by just as basic as it sounds, creating a grid, okay, of taking each type of transaction side by side and laying out the key requirements and the core and the core differences in each type of offering as it relates to KYC or any other type of compliance requirement for that matter. But I think you have to start there. And then I think you have to then train your employees on the nuances or the differences in each requirement. And then this is the other thing I said to you, and we talked about this with Marty. Firms should assess if they're doing 3 different types of distinct offerings or engaging in one versus the other at any point in time. Do they want to hold themselves to a higher standard? And whether or not that's practical, given the type of business they are in, and more importantly, is it practicable? Can they actually allocate the resources to creating a consistent process, regardless of the type of offering? And I think where I do want Marty to chime in after I say this next statement. I think where a lot of firms get caught up, and whether you're a funding portal or a broker dealer, is if they look at some of the lower tier types of requirements for a CF versus a Reg D type of deal, they think automatically, well, I don't have to do that. And even though the regulation may not say that you do, I think one of the things that firms will find out is their key counterparts or vendors may insist that they do these things at a higher level and check additional boxes to get comfortable in even dealing with them, whether it's a bank, a payments processor, a technology provider, whatever it may be. So I'll stop there, but maybe Marty wants to add something to that.
No, I agree with you 100%. And I think that's an interesting point about the, standard if you're doing these simultaneous offerings. There are, Reg CF, I think, has the most stringent, even though it's the lower amount and it's not a qualified offering by the SEC. So a lot of times people think, hey, we just have to file this thing and we're off to the races. But it does have a lot more restrictions around what can and can't be said. You have, there's there's requirements for notice and so forth. One of the things we didn't talk about last week, but was just this idea of marketing. Like we were talking about a Regulation A offerings and marketing, and if you're doing a simultaneous, or if your client is doing a simultaneous Reg A and Reg CF, basically you have to comply with that higher standard of Reg CF, because it's going to be presumed that even if it's a Reg A offering, or even if you're doing a 506C offering and bringing in accredited investors, it's going to be assumed that the people that come into that CF saw whatever you sent out, right? So you can't say, hey, this is notice that's being sent out to just our Reg A investors or just Reg D investors. It's going to presume whatever you send out it will be seen by the CF. So you've got to make sure you're complying with that higher standard, and that could be reflected in, like you said, in a grid.
Absolutely.
That you referenced.
Well, the grid just got more complex. I mean, the first grid was just, CF DNA, but you just said something interesting here that even I love learning, is that as soon as you start combining these regulations, and we're seeing that more and more now, you have to take the assumption of the following, and that changes the way you approach KYC. So that's an interesting observation. We're now seeing a lot of the following. We're seeing a lot of companies doing Reg CF and Reg Ds side by side. That is becoming a commonality that, because this one only gives them 5 million, they need more. But you're right, they're using the marketing of Reg CF to bring in but they are using 506C rule, which is good. I mean, I think those who try to say, hey, it's a 506B, it's kind of hard one to kind of dig our teeth into. So, but Marty, there was one question, with the grid and all that, one thing that I wanted to bring up first is that as we go, and this is my fault, and it should have been probably the first question, is that when a firm decides to engage in these exemptions, it's not just, hey, I'll just jump into Reg CF and Reg A. They do need to file documentation with FINRA to make sure they're allowed to do so. Am I correct on that?
Absolutely. I don't know if you want to take that, Marty, but I'm happy to chime in when
Go ahead.
Yeah. So I apologize. So we talked about this, I think, two sessions ago. Just because you're approved for private placements doesn't mean that FINRA thinks it doesn't necessarily mean you're approved for Reg CF deals. Okay. And so at a minimum, any firm that's thinking of engaging in CF that's never done a CF deal before should do a materiality consult with MAP at FINRA, just to let them know what they're thinking. Because, and I said this also in one of the prior sessions, we do a lot of new membership applications and continuing membership applications at CRC for clients who want to engage in these types of businesses. And if you say you're going to do private placements without qualifying it, MAP will really drill down and say, okay, do you mean Reg D? Do you mean Reg A? Do you mean Reg CF? Because they're going to want to make sure that you have incorporated the key characteristics, and differences in each type of offering in how you supervise those offerings. So don't think just because you've been approved to be a private placement agent that automatically incorporates Reg CF. FINRA may very well disagree with that assessment.
Marty?
Yeah, no, I agree. Yeah, we did talk about this two sessions ago. And I think that it's that, again, it's I don't want to beat a dead horse, but I think that's really important. It's a really important point that not only are you making sure FINRA is on board, but I think prior to that, you've got to make sure that you have the compliance pieces in place, that your supervisory procedures contain the elements that reflect those guidelines and provisions regarding the different types of offerings.
Yeah,
Okay.
the one thing, and again, I'm going to continue to beat the dead horse, but but it's a really good point that Marty just made, Oscar, because one of the things that FINRA looks at in terms of materiality is, will there be a material change in your operations that's required to support this activity? So if you've engaged in a old school Reg D type of private placement business, and suddenly you want to do Reg CF deals, there's going to be a significant investment in infrastructure to support that. And so that's exactly why FINRA wants to understand, because it's not, you may take the stance as a firm, well, a private placement is a private placement is a private placement. No, it isn't. And what you have to do to support that from a compliance and supervision standpoint may look like night and day depending on what you're doing. And so that's really the assessment that has to happen. And that materiality test really does look to see, do you do it with the same people? Can you do it leveraging the same systems? Oh, you need to implement new systems? That right then and there is going to be something that they're going to carefully consider before they say, yeah, you're good to go.
That's interesting. And that's good. Obviously, in order to go after that bigger market, there needs to be all the safety nets, both also from we're doing all the safety nets from the investor and everybody else, but the broker dealer also needs to be prepared if FINRA is looking to, looking for information. They want to know, where's the source of that data? Where is it? Coming back to that Rule 17A, where we started the whole conversation with a few weeks back.
So I have like an interesting question, and it's not an AML question per se, but it's something that I think, and I'm interested to hear from both you, Oscar, and Marty, if I may, because I meant to ask this in the last session. But when you're looking at potential investors in a Reg A deal, right? And let's just say Mitch Avnet is an employee of a broker dealer, and I want to invest in a Reg A deal. Would I be precluded from doing that because that's deemed to be an IPO?
No. It's, I mean, look, the way Reg A works and the way Reg CF and Reg D work, from at least in my view, and Marty, you've always corrected me when I'm wrong, so I don't have any problems with that, but I think I've gotten the basics of it, is that, from an investor perspective, as long as the suitability requirements have not been met. So Reg D suitability is you have to be accredited, and you have to go through a process to do that. Reg CF, there's a limit, and that limit is an annual limit, and you need to manage that. That's the part that Marty was nailing on. That I think that's where broker dealers have really fallen off on this one. They like Reg CF, and I don't think they realize that however many times Mitch invests with you, you have to keep track of that, and you have to make sure that Mitch never goes over the limit. And now with technology, of course, that solves that. In Reg A, it has a suitability, but that suitability is only attached to that investment, and it doesn't play into the other investments. But again, as the bigger the firm goes, you brought up an interesting point right from the beginning to that grid. What is your responsibility to that investor when they're investing in multiple regulations? And in each case, let's hypothetically, they're always going for the max, right? I mean, at what point does the responsibility kick in?
Well, so let me just chime in, because if you look at IPOs in the traditional sense, employees of broker dealers, there's a specific question that when you're opening up an account with a broker dealer, they ask if you're an employee of a broker dealer, because employees of broker dealers are, precluded from investing in IPOs. So from a regulatory perspective, and this is something I just thought about, and I struggle with thinking whether it's apples to apples, even though there's like an IPO component, I guess, to a Reg A, is that an apples to apples sort of comparison of
No.
I'm eligible to invest?
So
Marty,
I'll
the
jump
lawyer.
in here. This is where the SEC rules and FINRA kind of diverge, but from an SEC perspective, Reg A is an exemption from registration. So it's not it's just like a Reg
I
D or
agree
a
with
Reg
you.
CF. It's an exemption from a registration. But as far as FINRA goes, it considers Regulation A as a public offering subject to the corporate financing rules. So remember, members have to comply with Rule 5121, which is relating to conflicts of interest when it's participating in that, and it has a conflict of interest. So I would think that if there are people now, if they're employers are investing in that, I think it's just I think that's something that would be subject to those same rules and have to just be disclosed.
Got it. Yeah, it was something I thought about, and I was like, I wonder how folks are dealing with that or handling it.
Well,
yeah,
actually, it's because we never talk on the public side, Mitch. We've only, personally in our company, we've only dealt with 2 occasions where companies have done a direct listing after the offerings have been closed. After.
Got it.
And I love to tell you that it was harmoniously beautiful and it went nicely. It didn't. Neither of the worlds were ready, but we'll have a separate discussion on that.
Yeah, absolutely.
But,
Sorry.
no. I think, look, that's the whole point. I think the discussion today is really to focus on the KYC requirements and not to take this approach, as you said it, hey, I'm allowed to do private markets. I can do Reg D, the Reg CF and Reg A. No, you can't. As Marty alluded to, Mitch, you still need to apply, and there may be additional requirements you need to meet in order to be able to do those regulations. To my point, I just mentioned one big one, and I know FINRA has been focusing on this, is how do you know how many times Mitch invested with you? And the only way you can do that is you need systems in place, a very specific system that is keeping the tallies of the investments to make sure that Mitch has not gone over. Even though Mitch can update those updates, so it's okay to be doing just the Reg Ds, the odd, but as soon as you come up here, you do need to embrace technology, and you can't cut corners with it. And this is my view, and I want to hear yours first, Marty, and then your Mitch. So I'm a Reg D shop, and because this is what we do a lot. We find a lot of Reg D shops that go, hey, I think we want to get into the Reg CF and the Reg A, and we go, yeah, fine. Here's the tech, and we always tell them to go with their lawyers, get compliant. So in the Reg Ds, they go, we're going to keep doing it the same way we've been doing them, and now we're going to do the Reg CF and Reg A's this way. In my view, I call that 2 sets of books of record. Am I seeing that correctly, Marty?
Yeah, I think so. I mean, I think that you're going to have. I mean, again, it's tracking those things. I think that, and maybe this falls more on sort of the technology side, but with regards to those offerings, with regards to the tracking, and maybe I'm missing the question here, Oscar. Maybe I'm not.
No. I'll just say no. It's okay. It's okay. What I'm basically saying is that if with Reg CF and Reg A, it's all technology, right? So there's a system in place, monitoring and all that. With your Reg D investors, you're doing it the good old fashioned via email. You're submitting through another source. So are there any rules for that where again, transfer agent, your book of records are either electronic or they're paper-based. But if you're doing both, you're going to be, your audit is they're going to want paper and electronic on both, right? So it's the book of records. If they're used to doing it a certain way, the Reg D world, because the Reg D world, let's face it, look how they do it. They throw around a PPM if it is a deck. They get people to do a subscription agreement, sign documents, and the KYC, nobody knows where that's done, but let's assume it's done somewhere with another report, and then they package all that together and then wrap it up. And now they're using Reg A and Reg CF, which is completely wrapped up. Whichever they work, it's going to be a wrapper on it. So how does that get treated from FINRA point of view going forward?
Yeah, I can jump in on that one. And so you're a broker dealer at the end of the day, okay? And a broker dealer has record retention requirements under 17A3 and 17A4. And so just because historically you've been only doing Reg D deals, you have to look across all the record retention requirements specific to 17A3 and 17A4 and how they apply to you as a firm. And you have to go, we do these assessments all the time. We go business line by business line, desk by desk. And we look at what their business is. So it's not two different sets of books or three different sets of books and records requirements, Oscar. It's just another set of requirements of the types of records you have to retain based on the type of business that you're doing. And so now that you've done your Reg D, I've been doing that forever. I've checked all the boxes in terms of what I have to retain for 3 years, 5 years, life of the enterprise, whatever it may be. You have to do the same analysis once you start doing these other types of transactions and look at what the requirements are and make sure that you have the right retention in place in terms of grabbing those documents, making sure they're retained in the appropriate format, and for the duration of they're required to be retained for.
But wouldn't FINRA, I mean, so when FINRA knocks on the door of our broker-dealer, they go, we want to see the attestation, the email logs, the copy of that and all this, and that's all in the system, and here it is. But if they were doing it over there, so I guess what I'm hearing is FINRA is okay no matter what you're using in the back end for each of the regulations, as long as you're maintaining your record. Is that what I'm hearing?
Right. But if you're using technology that you're saying are the official books and records of the firm, you have a requirement to notify FINRA that KoreConX is my books and records. I'm just using that as an example.
Yeah, yes.
Okay. And to the extent you need to get a D3P letter from a designated third party that has access to those records, because KoreConX won't be a D3P, even though it's worm compliant, then you have to find a vendor that will help you meet those requirements. But I think what FINRA looks for, and it is low-hanging fruit, is we see what you disclose. You use Global Relay, you used AWS cloud, worm compliant cloud. Okay. We don't see KoreConX here, and it's your books and records. So before you use anything as your books and records, you need to make sure you're reaching out to your RMA or coordinator, which we used to call them, tell them what you're doing, and upload that information to FINRA so they understand that that's part of your books and records, and that you've notified FINRA within the prescribed time frame of prior to engaging in the activity of leveraging that as your books and records.
Marty, did you have anything to add to that, or you're?
No, I agree. I think that's great. Thanks, Mitch. I think that was perfect.
Okay, so let's move into the KYC side of it a little bit now, more digging in deep, because this is the one that we're seeing the most now. We're seeing broker-dealers struggling. How do they approach? And we started the conversation creating a grid, but there's some questions here that I've gone to Marty before and others, and they'll say, Oscar, you're correct. For Reg CF and Reg A, the broker-dealer does not need to open an account. Then I go back to Mitch, the CCO, and say, Mitch, you're okay on that when you get a pass. Maybe I'm using the wrong word, but you don't need to. So how does a CCO manage that? How do we make them? Because all CCOs now know that they can be on the hook. So what is the proper terminology that indicates that not so much they're off the hook, this is their only requirement, and because of that, you don't need to go any further. And then we can talk about what does a firm do if they want to provide a hybrid, and what the issues may arise from that hybrid model. Marty, did you want to slip in here first?
Sure. That was quite the question.
They always are from me. Come on.
It's one question in 27 parts.
Yeah. So talking about KYC, we've touched on this before, and the requirements for doing KYC, the initial conversation of, is it absolutely needed? And we talked about that last week. It's basically saying, well, not if, it's not required necessarily, like for like said, for an issuer, but now we're talking broker dealers. We're also talking, and we also brought up the idea that if this is going to go into a bank or be a secondary trading, then it would be needed. So it's best to gather that right from the beginning. So I think that same approach could and should apply, across the board, except for, I mean, when you're getting the sort of the just private placement, and I'm thinking about this more from an issuer's perspective, like what an issuer has to do. But with regards to a broker dealer, there are certain requirements that require people like broker dealers to not only develop and implement a AML KYC compliance program, but to obviously affect that or to put that into effect in their business. So from a broker dealer perspective, I don't know if there's much of a difference between, as we take these across the different offering types, you're gathering the same information, you're serving the same, it's serving the same purpose.
Well, before I send it, Mitch, I mean, you've run into this a lot in you guys' firm. You're always helping companies, because I'm seeing this is probably the biggest. I'm not going to say it's a major roadblock, but it's a major shift that I'm noticing with traditional CCOs right now who are in their place, and their firm has recognized, hey, I want to bring Reg A and Reg CF. And they go, on the Reg D world, this is what we do. We go through CRS, we go through Horizon, we ask them their risk factors. And then here they go, what? I'm not, how can I open this account? And it's that terminology, opening the account, that the conversation falls off. So I know we discussed it, that these are the requirements, but how do we give them that ease of moving forward? And making
and again, I don't think it's a one size fits all answer, Oscar. Okay. And a lot of it depends on the risk posture of an organization, right? And what they want to have in place in terms of their compliance program and the type of CCO they have in place at the end of the day. Okay. And so not all CCOs are created equally. Not all business models are created equally. And it's really going to come down to your risk posture. And, from as a career 21-year compliance officer, 13-year CCO, there are certain things that you can get away being a little bit more aggressive with than others. And they can be good risk decisions based on, what the reward is at the end of the day for taking that risk. But I've never seen an upside in the 30 years that I've been doing this of taking risk on the AML KYC side. So
no, that I agree. Just so you know, I'm just because they don't get to be opening an account, they still got to go through ID and AML. All that is 100% work. As Marty said, you don't get a pass on that. Even though there are lawyers out there saying that that's not needed, but for those, they should be listening to Marty when advising clients.
So listen, and there may be interpretations out there, and I'm making an analogy here. For years on the M&A side, a lot of M&A firms didn't think that they had to go through, a complete, AML KYC, since they were dealing with, they weren't opening up accounts for their M&A clients. There are definitely interpretations out there that say you don't need to open up an account for them to be viewed as a client based on a number of different characteristics within the relationship. So here's the thing that I always look at, and I know this is specific to FINRA, but everyone needs to look at this, is you may be trying to address one requirement, but breaking three others while you're doing that. Okay. And so just because you think you're okay here from a FINRA perspective, there may be a disconnect between, Marty pointed it to before on the conflict stuff, and the SEC looks at it this way, FINRA looks at it another way. Okay. And state regulators may look at it other ways, depending on jurisdictions. so that there may be different requirements. So the long and the short of it is, I don't think in and of itself opening up an account at the end of the day is the one metric you should be using to figure out whether or not you have a client relationship there.
That's a great point. I like that. That's a great. We're going to come back to that. So, I'm going to ask Marty this question. So this has come up a few times, and this happens quite a bit with Reg CF and Reg A only. Mitch is the accredited investor, right? And I come in and I tick the box and I enter the information, and voila, I can invest unlimited. So, which is what the regulation allows, and same thing for Regulation 8+. At what point do you think, if there is any, because it is a variable, I think it's a variable, does the broker-dealer have to do the verification on the investor, or do they?
For a Reg A or a Reg CF, they don't have to. I mean, that's it's self-verified, right? I mean, the only time that would come into play is if they had reason to believe, and I don't know under what circumstances they would, but they had reason to believe that wasn't true, right? If they, and I always use the example, like especially like on a 506, like a Reg D 506B offering, where it's, again, they just self-certify. If they check a box and say, I'm accredited, I make this much money or income, or I have this much in net assets, then that's typically sufficient, unless you know for fact that person doesn't. It's an employee, or it's somebody that and you just know that's not true. I don't think that a broker dealer has the same. I mean, typically this is also what you're bringing up, is this falls more on the issuer and less on the broker dealer. The issuer is the one that has to be concerned with that, and because the issuer is the one that's availing himself of that exemption, not the broker dealer. The broker dealer is just kind of in the middle there. So that's more of a broker, an issuer deal. So
we definitely don't want to give the question to the issuer, and they'll go, "Oh yeah, it's good." Let them go through.
Well, but that's where it does fall, right? I mean, that's the issuer is the one that's preparing these documents. It's their subscription agreements, and if again, that's if they under Reg CF or Reg A, if they have reason to know that somebody checked a box and they aren't accredited, then they can't rely on that specifically.
Okay, so I didn't have this as a question, and I'm going to stay with you there. So I've been doing Reg Ds. I got my engagement agreement with the issuer for that. Should I have a different type of agreement for Reg A and Reg CF to this point exactly? Because if I'm not mistaken, in the Reg D, it is the responsibility of the broker-dealer to ensure that investor is accredited.
I don't think it is.
No?
I don't think
no?
it,
oh, okay.
It's the responsibility of the broker. I still think that's an issuer. That falls on the issuer. Now, the broker-dealer, I think, as part of their, and Mitch, maybe you can jump in, but as part of their due diligence, their CIP program, you're not gathering financial information. So I guess, you just really have to make sure that the person is who they say they are, and that they, do the due diligence if you're doing an AML check or something like that. But again, you're not getting into financial information. Mitch, do you
and that
disagree?
begins on the particular rule exemption within Reg D that they're self-certifying. This is the one that's what you're talking about. But so help me understand something, and I'm asking this because I think it's something that there are folks in the industry that get confused about this at times, and I think it's good for us to discuss. And I'm talking, specific to Reg D now, right? But isn't there a requirement that the customer has to be known to the broker dealer before they can engage? Yeah. So how do we define known to the broker dealer?
Known to the broker dealer.
Like,
well, and again,
and because I've seen funds do this where they take a very conservative view of, you know, minimum length of a relationship versus others who are taking a very aggressive view of known to you. So it's something that I've grappled with.
Yeah, and I don't know, because I think this is one of those areas where FINRA rules and SEC guidance and rules are a little bit different. So, for example, and I'm going to take this maybe off track here, but like in a 506B offering, you have to have the key is you have to have a pre-existing and substantive relationship with the investor prior to them investing, which, you know, there's no bright line. There's some no action rules on this. Is there a period of time? What is that contact? You know, so you have people that are doing these 506B offerings where you come in, you sign up, you can't see any information about the offering. Then they sign up, somebody calls you, you get some emails back and forth. There's some waiting period, and then they say, great, now you can invest in, you know, the next offering that comes online. So that's kind of the advice we've given on the issuer side. But with regards to a broker dealer, do those same standards apply? What does it mean? I don't know. I don't know what it means to be known by them. You know, does it just mean, I've always actually interpreted that to mean that they've just done their basically their CIP, you know, they've received the information from the person, they've checked their identification, they've done, you know, whatever, their driver's license, their passport, they've done due diligence, and that means they're known. But that, I might be wrong on that. That's just the way I've always thought about that, but I don't know if that's correct or not.
But that's the 506B though. But 506C is different, right? Because
506C requires that a third party verify their financial information. I think what Mitch was asking is just this standard for broker dealers that customers have to be known. What does that mean?
Yeah.
Because it's not defined as a pre-existing substantive relationship. It just means that they have to be known. So does that just mean you have to basically verify that they are who they are? I don't know.
No, it's all, and you know, it wasn't. It was more to have the conversation because I think we all struggle with a definition around that. Where, you know, like I said, I've seen certain folks say, well, we're not going to allow your client to participate, you know, a private fund, okay, a Reg D private fund, unless you can evidence that they've been on board with you for a minimum of 6 months. And I'm like, where does that come from? And so I think there's a lot of subjectivity to it, to your point, Marty.
So we've agreed that in the Reg CF and Reg A, it's not the responsibility of the broker dealer to have the investor being accredited, but under the Reg D, it's same. You still believe that it's still the issuer responsibility, even though it's a broker dealer doing the offering. The investor needs to pass off on it and get the third party report in order to accept the funds. So that's the understanding that a broker dealer needs to have. I always understood it a little differently, and you tell me. I've always understood it that I retain a broker dealer and I'm targeting 506C. And yes, every investor that needs to come in needs to be accredited, and they're going to go through the accreditation, meaning they're going to get the report and make sure that the investors coming in in fact are accredited investors before they get added. So therefore, they're kind of taking that responsibility away from me because I'm unqualified to be able to, you know, the worst thing, I've seen the other side. I've seen where companies say, oh yeah, you're accredited. Okay, good to go. It's a 506C. Where's the report? Oh, I didn't know I needed that. Mitch said he was unaccredited. I trust him.
Yeah, and let me and I think Marty's right, and I think you're right. Okay, and because I think there's nuance in terms of how it needs to be described. So yes, it is the issuer's responsibility, but guess what? The issuer is hiring or retaining the broker dealer as the placement agent, and there's certain things that the broker dealer is going to do in conjunction with earning its fee for being the placement agent. And contractually, the issuer is going to rely on the broker-dealer to do all that vetting and escalate accordingly, because that's what the broker-dealer's job is. And so that will be laid out in the placement agent agreement in terms of who has what responsibility.
Yeah, and that's great. And I think the key word there was contractually, right? That contractually, those are their obligations. It falls on, you're outsourcing those responsibilities to the broker dealer. That's
yeah, and that's all I was trying to get at. As long as everybody's clear, right? Because look, I see the mess from both sides. I see it from the issuer where, oh, I didn't know. Well, you have to, and that's why if you get a broker dealer, they'll make sure that you are putting the proper people on your cap table, because you don't have to reverse it. So, all right. So now I want to move into ID and AML. And the reason I'm splitting those two up, not because they're not needed. That's not the question. We all agree. Nobody gets a pass on this. ID and AML, OFAC, all that's a standard. All it's a standard. The acronyms are standard. Okay. But here's the question that I have. If something is such a standard, why do we have a discrepancy between a report from one vendor to the other vendor? And we're not talking like 1 degree, we're talking sometimes 100 degrees away. How does a broker dealer work in that world when they're getting discrepancy at different reports, and in one the individual passes, on another one the individual fails? How do they go about doing that? I'll start with you, Mitch, because that's your heart and blood of compliance.
That's a long question. So listen, at the end of the day, I think a lot of the vendor platforms that are out there, at least the ones that we work with, are essentially pulling information from a lot of the same places. Okay, and so whether it's LexisNexis, Refinitiv, or whoever you're working with, you need to have, and this is how I've always looked at it. You need to have a reasonable process in place to complete those verifications, okay? And if that reasonable process in place means that you're relying on a vendor solution to assist in the completion of those tasks, your job is to ensure that that technology or that vendor platform is working as intended. So, but to what degree do you have to do that? And to me, if you have a robust program in place and you're leveraging industry recognized technology, and you have a process in place to review that, tune, retune, and again, the term I've always used and regulators have always used is a regular and rigorous process. So define regular and rigorous. So if you're relying on a technology to support this undertaking, at a minimum, in my belief, you should have a quarterly review of that technology to ensure it's working as intended. And if that means trying to run a review, and not easier said than done, I'm going to say that before I even go further. But if you have an ability to compare and contrast that to another platform, great. But at the end of the day, that's going to come down to the firm, their compliance infrastructure, and how they vet what vendors they're working with, and the reliability of that data. Okay. And so if I know that vendor A is pulling all this information from all these sources, and it's however many they are, I have to at some point be comfortable that it has, passed muster. The good news in a lot of situations is you have the broker dealer relying on one vendor platform, and you may have the clearing firm relying on another vendor platform with traditional products, right? So we see that a lot, where there's a mismatch between what the broker dealer says, oh, this is a good client, and the clearing firm says, no, wait a second, we have a couple of red flags here. So okay, so at least there's a check and balance in place, right? Okay. And so, but when you're dealing with private placements and alternative investments that aren't being cleared and settled in a traditional manner, again, you have to have a reasonable program in place. And far be it for me to tell you what your program should be versus what Marty's program. But at the end of the day, you have to feel it's defensible in terms of what you're doing.
And Marty, on that note, on the program, is that something that the broker dealer has to submit to FINRA, what they'll be, or that's just part of their operations manual that's kind of living and changing as time goes by?
Yeah, so that would be part of their supervisory procedures. So that's something, and that is something that's updated, but it's both, right? So that does get submitted to FINRA as part of their application, but it would also be something that, again, it needs to adjust and be a living document as they improve and as changes are made.
And look at it from this perspective. And again, I'm just using LexisNexis. This has and I have no information here. It's just using the name as an example. If I have a problem with LexisNexis, the rest of Wall Street has the same problem. Okay, so that's a bigger.
Thank you for saying that. Yeah, actually, that's a really good saying. I've been taking it pretty hard from some BD, the smaller BDs that moved into this space. And I'll give you some example. Oscar, your LexisNexis is broken. How can it be broken? It's red flagging this investor. I checked their social security number. It's good. I go, they don't just check the social security number. They're checking everything. They're checking all the information they provided to give you a verification that this person is real. Like, you have no way of knowing that online just because. And it's come to, like, I've gone into situations where I have to get LexisNexis on the call to, hey, listen, we're pulling data from all these different sources. This is the most reliable data source you will have. This individual has been red flagged for these reasons. But I checked it over here. So what they're going to these social security verifiers. I've checked them. You put in the social security number, it just tells you it's good.
Yeah,
but it doesn't tell me that's Mitch or Marty.
It's just one component of which should be a very comprehensive review based on a number of different data sources that they're pulling from. So again, the more reliable the vendor in that regard, and again, there's a lot of good options out there, and so it really has to be right sized for what you're doing. And I encourage firms that are getting these, whether it false positives or seeing this on a recurring basis, that bad information is coming back from whatever vendor. You need to track that, and you need to really reach out to the vendor. And especially if you see a pattern or practice of behavior like this just doesn't reconcile. What am I missing here? And again, so it's incumbent upon the firm to have a process in place to document all of these things. And then over time, I'm a big believer in statistical analysis over periods of time, where you can say that over this period of time, whether it's quarter by quarter, year by year, you kicked out a bunch of garbage. Why is that?
Yeah. Yes. That's an interesting point. I guess and I make the naive thought that from a broker dealer point of view, I go to that source and I get the report, and all of them are going to be the same, but it's a variable to your point.
And the one thing I'll always say, and I'm sure Marty will back me up here, is you can outsource the task, you can't outsource the liability.
Yeah, and in that situation, it's probably good to have. I mean, if you're consistently seeing that errors or things coming up or things being missed, it might be wise to have sort of some redundancies in there. And that's kind of part of one of the requirements of these AML programs, which is you need to have this sort of independent testing and auditing done and have that being performed, on a regular basis, so you can make sure that what the program you have in place is is doing its job, because like Mitch said,
It's
you can outsource you can't outsource that liability.
But and you know, in the broker dealer world, you know, again, you know, we do a ton of independent AML reviews every year, and we look at all these sorts of things and test against it.
Yeah.
So the last question that this one is, it's coming up more often. I've been reading about this, and so I'm going to start with Marty regarding bad actor. So I'm getting pushback. I know it's going to sound really hilarious from broker dealers. What do I need to do this? I don't need this. I never needed it before. So I don't know when bad actor requirements came in, but from what I understand, they are mandatory for Reg CF, Reg A, and Reg D. Can you shed some light on that, Marty, from a broker dealer funding platform perspective?
Yeah. So what you're saying is basically, again, this we're making these distinctions back and forth about FINRA rules versus the SEC. To avail yourself of these exemptions under the SEC rules, these exemptions from registrations, then you can't have the principles of the issuer cannot be quote unquote a bad actor. So I think then where this goes across is that if you are outsourcing, if you're a broker dealer and you're helping your client do one of these offerings, it's incumbent upon that broker dealer to say, okay, well, let's just make sure they're eligible for this offering by doing a bad actor check. Because if they're not eligible, then you're basically helping them engage in a unregistered securities offering that's not eligible for an exemption. So I think you have that sort of base level, but then you have this other level of just broker dealers are there to provide a level of protection for investors. If an investor invests in an offering and it's offered by a broker dealer, they're presuming that broker dealer has done their due diligence on the issuer and the offering, and that offering is going to be you're relaying some level of confidence. And if there's a bad actor involved in that, then obviously you're breaching that duty to your investors.
Mitch, your thoughts?
Definitely. And so, so I think it's really important. And contractually, I see a lot of platforms rushing to get deals on their platform. Okay. And the one thing I would caution anyone listening is make sure, for each of your agreements, whether it's for a CF deal, a Reg A deal, Reg D, that you have termination language embedded in it that, yeah, we're going to sign you up to do this offering on our platform, but it's going to be subject to due diligence. Okay. And if anything comes out of that due diligence that makes us squeamish, we have the right to terminate. Right. And that's really part and parcel of doing these bad actor checks, because to Marty's point, there is a responsibility there, because you would have then essentially aided and abetted a bad actor from engaging in a securities offering and they were ineligible, and now you're in the mix. So you need to make sure that you have that language embedded across all your agreements, and don't just assume it's there. Reread your agreements and look at all those termination provisions, because you need to have a put or an out in these sorts of scenarios.
Oh yeah, I that. Well, let me throw this at you, Marty. What about from an investor? Can a bad actor investor invest in an opportunity? Is there any obligation from the broker dealer to do bad actor check on an investor?
Well, I mean, a bad actor investor is not going to blow the exemption. I think that just goes into that sort of your AML, your KYC AML program. I mean, I think that if you do those checks and something comes up, it's incumbent upon the broker dealer to be that first line of defense against that. A bad actor, it's pretty vague, and you can have that can be something that they I've had clients, unfortunately, that have been subject to SEC actions for very minor things, and there's still sort of that censor on their record, and so I think that, again, if the broker dealer is just doing their due diligence, they're doing that, they have that AML program in place and a CIP program in place, then and nothing's coming up, I don't think that that's something that they would be cause them any problems.
Let me ask you a follow-up question on that, because I don't think there's any regulatory requirement. I think a broker dealer can decide that they don't want to do business with anyone for any reason, correct?
Correct.
Right?
Yes.
And so if there's some kind of hair on somebody, and they don't even have to give a reason, right?
Correct. Yeah.
So I think if there's something that makes you uncomfortable, you trust your gut. Okay. And, real life example, I have a client, and not a bad actor sort of scenario, but the individual who was trying to open up an account, their personal email address was very offensive. They decided, we're not going to do business with this person.
Well, okay. So that leads to, is there any responsibility, do you think, within broker dealers that to flag potential, because there's now it's going to be online now. Before, the old days was Joe Smith and you put them in your folder.
Sure.
Is there any provisions prohibiting them from me saying, hey, Marty, I red flagged this IP address, this email address, I don't know what the name, but these are the two. Is that something that broker dealers can do with each other? Do you think is that allowed?
I think under 314B, which is a provision that allows firms to share information with one another, and you have to subscribe to that program. But then you can share that type of information to help these people from going to financial services firm to financial services firm to financial services firm. But again, you would have to be part of that program, but you can share certain information that enables other financial institutions to protect themselves.
Okay. Marty, did you want to add anything to that?
No, again, you have to be part of that program, because I think there's obviously privacy.
Correct.
Yeah,
you got to get around. So
yeah, it's starting to come up in our world. We're starting to hear that request. We're letting broker dealers tag it for themselves, and others are saying, hey, if I'm doing it, do you think it would be helpful for other broker dealers? It's not including the name; it's just the IP address and the email address as well. We're tagging whatever LexisNexis came back with the report. But you're right. There's other considerations that need to be handled down in privacy. But here's the conclusion I got out of this today. And this is, I think, I've learned to respect something quite a bit today. And that's, which is KYC for all the regulations looks like ABC in a grid, because I was really simplifying it after our last chat, Mitch. I thought I had it down, but I'm going to say with this caveat. Yeah, but I'm going to say with this caveat, exactly. There's a lot of different scenarios, like to the one Marty said. What happens when you got a live offering with these two regulations? What are your responsibilities from a KYC? So I think it's a living KYC information, but more importantly, you need to document it, you need to follow it, and you need to understand what it means. So which is, I think, is really important. And then when it comes down to the nitty gritty items, like when you're getting different reports that you may not agree with, that's not a bad thing. It's just telling you there's something here that's not adding up. And I think that's a good thing. we're treating it as, you know what, this is going to help you. We're trying to help you make sure you're not landed in hot water. So let's investigate. What, I know sometimes it's very difficult for broker dealers to do this when they're only earning a very small percentage in the Reg CF and Reg A deals, but maybe we need to change that, because the amount of work that they do, people need to see it, that it's not just, hey, ID and AML. There's work to be done there. But I think the bigger one, I think, is that they need to understand what that is. So this is the one thing that I got out of this today. I think the same way that issuers and the market uses ID and AML and KYC, they spit it out like it's some sort of Cheerio. They don't really understand what makes that up. I'm not saying all BDs are like that. That would be wrong, but I'm just saying, those that just rely on third parties. So I think, coming back to what you said, Mitch, you've got to have a robust plan, but you've got to start talking to the right players. And I'm not suggesting I'm one of them. I'm suggesting it's you, Marty, and you, Mitch, because they need to go through that. And one last question for both of you. Should they be doing that annually, Marty?
Yeah, if not, at a minimum annually.
A minimum, okay.
Most supervisor procedures talk about things being done on an annual basis. Some stuff should be done more frequently, but I think that, and if there's changes to the law, then obviously you need to make sure that you're compliant with those. But yeah, I would say you annually need to make sure you're reviewing those. And most procedures will dictate not only, hey, here's our policy, but it'll talk about who's responsible for that policy, who's responsible for enforcing and overseeing it. It'll include training. This is the training, or how periodic or how often training is done, how that's done, and then how often you'll do these audits or tests of the system.
Mitch.
Yeah, said perfectly. I come back to regular and rigorous. And there are certain things that you have to do on an annual basis. And Marty's completely spot on. Firms review their WSPs on an annual basis. But there are other things that you should be looking at, especially given systems that you're relying upon. And, technology is great. It enables us to do so much more than we used to be able to. But technology breaks, okay? And at the end of the day, it's our job to ensure that technology continues to work as intended. And unfortunately, with so many types of technology as it relates to regulatory compliance, it's not a set it and forget it sort of thing, okay? Things are consistently changing, new rules, amendments to rules. So you really need to constantly tune, retune, and it's my painting the bridge analogy. Once you get to one side, you're going to go back and paint the other every time. So that's how you have to approach your program.
Perfect. Well, this was a great chat as always. And I guess again, my takeaways today is just like always, constantly be talking to the experts first from the regulatory side before you start just jumping in or making assumptions, because the assumptions will not give you a pass from any issues with FINRA or the SEC if there is an issue to be had. So I want to thank you both. This is, this all got started, just so you know, Marty and I sitting down in Salt Lake, and I said, you know what, I'm sure Marty gets tired of repeating himself all the time. I go, Marty, I have this scenario. Didn't we talk about this? Yes, we did. I need it again. It's amazing how it just keeps coming back. So what our goal was here was to create something where, for those who are not able to make it, but to be able to see that here's what the industry is telling you, the experts are providing you, so you can put your firm on the right track, or if you're trying to engage in this market and take advantage of it, because it is growth. I mean, look, Reg CF and Reg A, they're here to stay. They're not going away. It's got problems like every other regulation. So I'm thankful for the both of you to spend the last few weeks with me to go through this. And I know that what I learned about compliance is like a tree. It just keeps growing, it keeps evolving, and as long as you keep monitoring it and making sure you're taking care of it, everything's going to be very fruitful. And so thanks to both of you, part of our ecosystem, being core partners. It's been great to have you on board today. If anybody needs to reach Marty, he's very easy. Go to KoreSummit.com. Go to speakers. You'll see his bio, his email address, and his LinkedIn profile as well for Mitch Avnet at Clear Risk, and their contact details. Sorry, compliance risk. Oh, thank you. This is the first time I made that mistake.
Who is this Clear Risk?
I don't actually.
New sponsor.
Yeah. Are you stepping out on me, Oscar?
No, I'm not stepping out. I'm usually stay pretty tight, but yeah, get a hold of them, or if you can't find them there, just reach out to me. I'll put you in contact with them right away. The most important thing to do is just reach out, get this engagement before you step into it, because if you're not listening to what the SEC is doing, they're enforcing. So therefore, we don't want you to be on that side. Until next time, thank you again, everyone. And we'll see you at our next KoreSummit Webinar Series in 2024. Till then, thank you.